Welcome to Capital Dateline Online, and I'm with our guest, the executive editor of the News Service of Florida, Jim Saunders. Let's talk today, Jim, about the Supreme Court. There's been a couple of decisions that have come up, and one of them is on solar energy.
Yeah, the Florida voters this fall are now going to be able to vote on a constitutional amendment about solar energy. And this is going to be a fairly controversial issue and has been controversial for several months now. The Supreme Court voted 4-3 last week to approve a proposed constitutional amendment that has been supported by the major electric utilities in the state: Florida Power and Light, Gulf Power, Tampa Electric, and Duke Energy. And this is in reaction to an earlier proposed constitutional amendment that some environmental groups were supporting. And that proposed amendment, would have allowed property owners to essentially sell small amounts of electricity to neighboring properties. The utilities didn't like this, so they put up their own proposed constitutional amendment, went out and spent several millions of dollars to collect petition signatures, and then went to the Supreme Court and got approval of the ballot wording. The Supreme Court only looks at the wording to make sure it's legal. It doesn't look at the merits of the amendment. Meanwhile, the environmentalists' proposal didn't make the ballot because they didn't get enough petition signatures, but they are vowing to fight the utilities the coming months on this amendment that's going to go there. It's sort of the backdrop a little bit is that there's fights going on in various parts of the country about the future of solar energy, how it's going to be regulated, how it's going to interplay, if you will, with the traditional electric grid system and the utilities. And this proposed constitutional amendment, the utilities are supporting. It's by this group called Consumers for Smart Solar, which is, again, backed by the utilities. And in some ways, it just goes along with the status quo of it would put in the Florida Constitution that people can essentially have rooftop solar and so on, which is the current. But there's another part of that, a proposed amendment, is what kind of is the real nut of the issue, I think, for the utilities, and that is to try to make sure that that solar energy will not, it won't allow, if there's a large expansion of solar energy, it will not allow extra costs to be passed on to consumers who don't have solar energy. Exactly. The utilities' concern is, I think, that there's going to be a large amount of solar energy, people going off the grid essentially, and that the utilities are saying, hey, we've got all these expenses to keep the grid going, to have the poles up, the lines up, and if you take so much revenue out of it, we're going to have to increase the prices for other people who don't have solar. That's their argument. So this constitutional amendment would try to prevent that. The other side of this issue, debate, primarily it's led by a group called Southern Alliance for Clean Energy. They are saying basically that the utilities are trying to rig the system so that it will benefit them and prevent other types of solar providers and plans from ever moving forward in the state. So I think it's going to be a really interesting debate over the next several months. The Supreme Court was very divided on it, as I said, 4-3, and the dissent was pretty harshly worded about it as well.
And they've also been discussing another topic at the Supreme Court, which is workers' compensation.
Yeah, this week, there's going to be a big hearing on workers' comp insurance. This is a really difficult issue. It's
very arcane.
It's very arcane. Yeah. There's a ton of different groups involved. There's insurance industry, there's business groups, there's labor groups, there's medical groups, because they get paid to provide these services. But this whole issue goes back to a 2003 law that was passed in 2003 by the legislature and then Governor Jeb Bush. That came at a time when workers' comp insurance rates were going very high for businesses in Florida. So they went in and redid the whole system and to try to lower rates, which has happened. But the other side of that debate is that labor groups, trial lawyers, they're arguing that so many benefits have been taken away from workers, injured workers, that the system is unconstitutional at this point. This case on Wednesday involves an injury to a nurse at a hospital in Miami-Dade County. That's the impetus of this case. But it goes to a sort of a fundamental underpinning of the whole workers' comp system, which is that workers won't be able to go to file normal lawsuits about their benefits. It goes into the workers' comp system, which is supposed to be streamlined. It's supposed to allow workers to get the care they need, some benefits, and then go back to work. That's the whole premise of the system. The trial lawyers and the labor groups are saying, you know, the benefits were so diluted in this 2003 law that trade-off doesn't work anymore. That the workers' comp system isn't fair to injured workers. They can't go to court, and yet they are forced to go through the current system without enough benefits. Now the business groups are arguing, and the insurance industry is arguing, you do away with this 2003 law. If this court were to do that, all those lowered rates and so on that resulted from the 2003 law would go away, and that there would be a spike in costs for businesses, a spike in costs in insurance rates. One other point is that there are 2 other cases pending in the Florida Supreme Court. They've already been argued more than a year ago, challenging this 2003 law. So I think there's a lot of thought out there that the Supreme Court is going to look at all 3 of these cases after Wednesday. The hearing is Wednesday of this week. After that hearing, the Supreme Court's going to take a look at all of these issues and determine sort of what the legal future, at least, of the workers' comp system is. I think it's really possible that if the Supreme Court were to rule against the system, to strike down major parts of the system, the legislature may have to come back into special session. I already know that, I've been told by one business group particularly, that they have already started working on a potential legislative fix if necessary. So that's something that maybe months from now, but the legislature might have to act if the Supreme Court rules against the workers' comp law.
Wow. Okay. Thanks, Jim. For more about Florida politics and government, visit the Advances section of our website and keep coming back to Capitol Dateline online for daily postings.